The FTC has officially banned non-competes. What does this mean for you as an employer and your current or former employees under non-competes right now? Hey, I'm Morgan Davis. I'm a business attorney based in Raleigh, North Carolina. I focus on cannabis and wellness. Let's talk about how to keep your business protected and thriving. So the Federal Trade Commission has issued a final rule that non-competes are void. And it's applicable to pretty much every employer and every one of their employees that is under a non-compete currently or is a past employee who's still under a non-compete. There is an exception, which we'll talk about in more detail in a minute, for senior executives and how the rule defines that. The FTC announced this potential rule in January of 2023, and we've been waiting to see what the final ruling would look like. So here it goes. Specifically, 120 days after the effective date, which is the date that it will be filed with the Federal Register, the rule prohibits entering into new non-competes after the effective date, including senior executives. So basically, on the effective date plus 120 days, you cannot enter into any new non-competes, okay? Existing non-competes with senior executives will stay in force, but all other existing non-competes with other employees are void. They are unenforceable. Existing non-competes with former employees are non-enforceable. In addition to that, if you are an employer, not only are they not enforceable, you have an affirmative duty to inform your employees under a current non-compete or past employees under a current non-compete that that non-compete is not enforceable. The definition of non-compete does not include prohibitions on competing during employment with the employer. This is non-compete agreements that cover the time for you after you are an employee, right? So how we see this most of the time is when you're an employee, and especially in a services industry or especially in an industry where there is proprietary business information that you're going to have access to, then your employer, as part of your employment agreement, will have a covenant to not compete. And it will say for a certain period of time after you are terminated from employment, you will not enter into any business that is similar to the employer. Sometimes they're extremely broad in general. Sometimes they're narrowly tailored to what you're doing and your position and a geographical location. And lots of times it's somewhere in between. None of them are enforceable moving forward. While you are an employee, this does not prevent your employer from enforcing non-competes against you while you are an active employee. But once you have entered that post-termination phase that would generally be covered by a non-compete agreement, this is not enforceable. Non-solicitation provisions and non-disclosure agreements are not at this moment covered by this rule. Doesn't mean we won't be watching to see if that changes in the future, but at this moment, those tools are still available to employers. Sale of business scenarios are excluded from this rule. So for example, if you are entering into the sale of your business or transacting in the sale of two businesses, those types of non-competes are not covered by this. This is to address the traditional employer-employee relationship. The one exception is for senior executives. Senior executives who are currently in non-competes and meet the definition of senior executive, those non-competes stay in place. So the definition of a senior executive is someone who is earning more than $151,164 annually and who's involved in policy-making decisions. As you can tell, there are probably going to be some litigation around the second part of that, which is involved in policy-making decisions. But nonetheless, if you don't fall into this category, then your non-compete is void. For employers, this is a big change. Non-compete agreements have been used as a tool to protect proprietary information and to protect your business for a very long time. In the medical spa space, it's extremely common for medical spa owners or operators to use non-compete agreements in bringing on service providers. Why? Because it's a services-based industry. And like any services-based industry, clients come to see a specific service provider. Whatever injector they really like, whatever esthetician they really like, fill in the blank, that's the person they're there to see. Yeah, I'm sure they love your spa, but really it's Jenny who they love, right? Well, when Jenny leaves and you've invested 5 years of training and courtship and love into her, you don't want Jenny taking all of the medical spa clients that love her, that are part of your business, as part of her new book to wherever she's going, right? And you certainly don't want her going down the street and opening Jenny's own medical spa with all those clients, because that then is in direct competition with you. However, moving forward, based on this current ruling, you cannot do that. Jenny gets to leave. Now, she may not solicit your clients, but as we all know, loyalty is loyalty. And if clients want to go with Jenny, they're going to find a way to go with Jenny. But that's exactly what the FTC is trying to do here. They're aware of that, and they're hoping for that. Because the underlying premise of this ruling is that non-competes stifle American business, is that non-competes prevent employees from seeking better positions, better job opportunities more in line with what they want to do, and instead focuses all the attention and protection on employers. And the FTC says that's not part of the American dream and we're not doing it anymore. There's a lot of speculation that this rule will be litigated in the courts and therefore may change. At the moment, though, it stands. If you have questions about your existing non-competes or what kind of tools you can use moving forward as an employer that does not involve a non-compete, give us a call. We'd love to talk to you about current compliance with this new rule and future options for employer-employee relationships.